Hi everyone. Today we are going to cover Chapter 11. Chapter 11 focuses on specialized patient records. Okay, so to begin, to give you some brief background, all health information has to be treated with care, and certain categories of health information demand special treatment. As we had discussed in prior discussions, um, information that requires special handling include genetic information, substance abuse and mental health care, home care, HIV information, and there are strict legal requirements to adhere to for handling these types of health information. As a general rule, most legal questions associated with managing health information cannot be answered by looking to federal law. One exception to this rule exists in the context of drug and alcohol abuse treatment. In such a context, federal law speaks directly to the handling of such health information. There are two federal laws that place restriction on the disclosure and use of substance abuse patient records. This includes the Drug Abuse Prevention, Treatment, and Rehabilitation Act that addresses drug abuse patient records, and the Comprehensive Alcohol Abuse and Alcohol Prevention, Treatment, and Rehabilitation Act of 1970 that addresses alcohol abuse patient records. Both laws delegate to the Secretary of Health and Human Services the power to promulgate rules and regulations imposing restrictions on these records. The rules and regulations that the Secretary has promulgated apply to all treatment programs that receive federal assistance. The federal regulations at issue are broad in scope and detail and address many issues central to the management of health information. All who work in the substance abuse area must become familiar with these regulations. The theme that underlying these regulations is that the health information contained in patient records is confidential. Therefore, only disclosure with patient authorization should be permitted. Therefore, the discussion focuses on two main areas, the confidentiality and release of information, and only briefly addresses other issues. Under applicable regulations, confidentiality of health information is much stricter than in the acute care setting. The regulations restrict identification of a patient who is in a facility or component of a facility publicly identified as providing substance abuse treatment. Acknowledgement of the presence or past presence of a patient can be made only with the patient's written consent or subject to a court order that's entered in compliance with the regulations. The issue of patient identification comes into play because of the number of inquiries treatment programs receive concerning their patients. The applicable regulations place an unconditional obligation on the programs not to identify in any way the patients they treat or have treated. These regulations do not prevent a program from disclosing that a person is not and never was a patient with its program. Those involved in substance abuse treatment should adopt uniform method of answering inquiries. Patients have to be given notice of federal confidentiality requirements upon being admitted to a program or soon thereafter. This patient notice must include a written summary of the federal law and regulations. The regulations allow programs to develop their own notices or use a sample notice. Because regulations require unconditional compliance, it's important that every treatment program document in each patient's health record that such notice was given and that the time frame in which it was given. Federal regulations govern the disclosure of patient information, and it falls into three main categories. The first being disclosures made with written patient authorization. The second is those that are made without written patient authorization but pursuant to federal regulation. And third, those that made subject to a valid court order. The disclosure of patient information in the substance abuse context involves the use of a release of information form. a document that permits the dissemination of confidential health information to third parties. The components of a valid authorization are illustrated on this slide below, and they are to include the name of a program or person that's permitted to make disclosure, the name or title of the individual or the name of the organization to which disclosure is to be made, the name of the patient, the purpose of the disclosure, how much and what kind of information is to be disclosed, the signature of the patient, and when required for a patient who's a minor, the signature of a person authorized to give consent, the date on which the consent is signed, a statement that the consent is subject to revocation at any time except to the extent that the program or person which is to make the disclosure has already acted in reliance on it, and finally, the date, event, or condition upon which the consent will expire if not revoked before. Regulations allow programs to develop their own forms that comply with the regulations or use a sample form. The sample form usually contains reference to the signature of the parent or guardian where required. The question of whether a minor can authorize the disclosure of health information in the substance abuse context is dependent on whether the applicable state law permits the minor to consent for treatment. Where the minor can apply for and obtain substance abuse treatment on her own behalf, she may also authorize the disclosure of health information. Conversely, where state law requires a parental consent to treatment, the authorization to disclose health information must contain signatures of both the minor patient as well as the parent or guardian. A release of information form that does not comply with the regulations is not valid. Examples of invalid release forms include those in which any of the elements are missing, the consent period has expired or is known to have been revoked, or that contain information that is known to be false or reasonably should be known as false. Those involved in the release of health information should develop policies on how to respond to invalid authorization forms after first reviewing the regulations and speaking with legal counsel as necessary. Another difference between a general release of information and that used for substance abuse programs is the regulation prohibiting redisclosure. Federal regulations prohibit a person or a facility receiving patient information from further disclosing the information unless the patient has given written consent addressing this redisclosure. A notice prohibiting redisclosure must accompany any disclosure of patient-specific information. In this situation, the regulations do not give any freedom to the program to develop the notice prohibiting redisclosure. Instead, each program must use the statement listed in the regulation. This statement is known as the notice prohibiting redisclosure and is located in the textbook in chapter 11 under figure 11.4. The sensitive nature of patient information in the substance abuse context requires release of patient information by written authorization. The regulations recognize only limited exceptions to the written authorization requirements, and they include medical emergencies, research activities, and audit activities. In any given day, a health information manager or director at a substance abuse treatment program may be presented with a discovery request for the production of documents, a court order authorizing the disclosure of patient-specific information, a subpoena requesting patient-specific information, or a combination of these. Discovery requests, court orders, and subpoenas are issued for a variety of reasons, to include to investigate or prosecute a crime, to protect against an existing threat or serious bodily injury, or to prevent evidence of a patient's substance abuse treatment in a legal proceeding where the patient has placed her treatment at issue. It's important to understand the differences between these types of legal processes. A discovery request is to produce a health record and seeks disclosure of patient-specific data or records that may be used in litigation. A subpoena, or a subpoena ducis tecum, is a command to appear and or present certain documents and other things. A subpoena or a subpoena ducis tecum alone does not authorize the disclosure of information that would otherwise be prohibited by statute and regulation. In combination, these documents mandate the disclosure of patient-specific information unless a valid legal defense exists against the disclosure. A court order authorizes the disclosure of patient-specific information that would otherwise be prohibited by statute and regulation. Court orders authorizing the disclosure will only be issued upon a finding of good cause. There exists no other way to obtain the information, and the public interest and need for disclosure outweighs the potential impact on the patient. Components of a valid order include limiting disclosure to essential parts of the record, limiting the disclosure to people who need to know, and including measures to protect the patient. How a health information manager or director handles these discovery requests, court orders, and subpoena in practice is a matter that's governed by both federal regulations and common sense. Health information managers and directors should develop policies, processes, and procedures for handling these types of situations. Commonly referred to as a litigation response plan, these policies, processes, and procedures may include contacting the attorney upon receipt of a subpoena, informing him or herself of the regulations prohibiting disclosure, and notifying themselves that a court order is necessary before the health information manager or director will disclose the information. Although federal law directly regulates substance abuse patient records, these regulations expressly recognize that the states will play a role in regulating these types of records. This recognition allows the laws and regulations of the different jurisdiction, both state and federal, to coexist, as opposed to excluding the states from any role. State law and regulation may be equal to, less restrictive than, or more restrictive than federal law. When a conflict between federal and state law appears, whichever law is stricter will apply. Where a matter is not addressed by federal law, the state law will apply. For several reasons, a treatment program may be discontinued or acquired by another program. In these types of situations, regulations that expressly address the disposition of substance abuse records. Under the regulations, the records must be purged of patient identifying information or destroyed unless the patient's written consent is obtained to transfer the record, or the applicable statute of limitations requires that the records be maintained for a period beyond the closure or transfer. If the transfer has not been authorized and the records must be retained for the statute of limitations period, the records must be then placed in a sealed envelope or other contained and labeled as the record of X, Y, and Z, which is the name of the program, required to be maintained under the citation of the statute, regulation, court order, or other legal authority requiring the records be kept until a date not later than, and you insert an appropriate date. The regulations require that a responsible person hold these seals and mark records in a confidence until the end of the retention period specified on a label. Upon expiration of the retention period, that responsible person is allowed to then destroy the records. Because of one of the main purposes of regulations is to ensure patients seek treatment for substance abuse are not more vulnerable due to availability of the patient record, and those who do not seek treatment, the regulations provide for an enhanced enforcement mechanism and criminal penalty for violations. The regulations assume that all federally assisted substance abuse programs will comply with restrictions that the regulations impose. Any violation of the regulations may be reported to the U.S. Attorney for the district in which the violation occurred, or to the FDA if a methadone program is involved. Upon conviction, any person who is found to have violated the regulations may be fined no more than $500 if it is the first offense and no more than $5,000 for each subsequent offense. The treatment of patients with mental illness or developmental disabilities takes place in a variety of different settings, including inpatient psychiatric hospitals, residential treatment facilities, and a therapist's office, just to name a few. Although the settings may vary, many of the legal questions concerning mental health and developmental disability information are the same as those involved in the health information in general. The requirements for accurate and timely documentation, the retention of health records, and the confidentiality of health information. Although many similarities do exist, there are two main differences that separate health information in these contexts from that of the general medical context. The first is that additional requirements for record content, and the second, there's more stringent privacy requirements. The documentation in the mental health and developmental disability fields often involves situations that are not present in the general health record. For example, these settings may involve changes in the patient's supervision, significant legal events, and the presence of suicide attempts. In addition, restrictions on patient rights may become necessary under certain circumstances. As a matter of both law and good medical practice, each of these situations requires the proper documentation in health records. Any psychiatric facility that receives Medicare funds, the Medicare conditions of participation govern. These regulations establish that standards for documenting the development of assessment and diagnostic data, psychiatric evaluation, treatment plan, recording patient progress, discharge plan, and summary. Frequently, state mental health codes specify the documentation requirements in these types of situations. Special attention is needed to be accorded to these codes in order for the healthcare providers to be in compliance with the state law. Where restraints are applied to a patient, for example, the clinical record must accurately reflect each use of restraint and its reason. Similarly, any limitation on the patient's right to correspondence, visitors, phone call, or access to a spiritual advisor must be documented in the clinical record, along with the reason for the limitation. Any use of special treatment procedures, such as electroshock therapy and neuroleptic medication, also requires the documentation. In addition to the statutory and regulatory requirements, accrediting standards may mandate that certain documentation is required. The Joint Commission promulgates standards for facilities that offer mental health, mental retardation, and developmental disability services. In addition to the standard documentation requirements, the Joint Commission requires that documentation of a patient's legal status and the involvement of family members in the patient's treatment program. Another significant departure from a general health record involves the existence of two separate records. The two records are the first being the official or public record maintained by the treatment facility, and the second being the personal record maintained by the clinician. As with facilities that offer substance abuse treatment, facilities that offer mental health and developmental disability treatment are subject to strict confidentiality requirements. The fact that an individual is, was, or will be a patient at the facility may not be disclosed absent patient consent. In addition, patient-specific information that's recorded and communications made in the course of providing mental health or developmental disability services are considered confidential and may not be disclosed except as provided by law. Disclosure may be made pursuant to a patient's written authorization, without a patient's written authorization under limited circumstances, or pursuant to a court order. As in any portion of the healthcare delivery system, health information in the home healthcare setting is subject to legal considerations. Unfortunately, there is no one comprehensive law that exists to address the legal requirements for home healthcare. Instead, the legal requirements arise from a myriad of sources that include Medicare, conditions of participation, state law and regulations, and the accrediting standards. For any home health care agencies that receive Medicare funds, the Medicare conditions of participation govern. These regulations outline the qualifications for home health agency staff and detail the rights of patients treated by the staff. The regulations require that the patient be informed of their rights in advance of or during the initial treatment, and that the agency maintain the documentation of that notification. The regulations also specify that all clinical records that are maintained by the home health agency are confidential, and that the agency must advise the patient of its policies and procedures regarding the disclosure of clinical records. Home health agencies must also meet the requirements of state law. State law may consist of statute, regulation, or a mix of both. The applicable state law frequently contains many of the same provisions that are found in the Medicare regulations. The statute also addresses confidentiality and disclosure of information, specifying that the patient's written consent or that of the patient's guardian must be obtained before health information may be disclosed. Regulations are often found in the context of the state-administered Medicaid program or the licensing requirements for home healthcare agencies. Where state laws or regulations do not specifically address home healthcare, the health information manager or director should determine whether county requirements govern. These requirements would typically be issued by the county's Department of Health or Social Services. Although accrediting standards and professional guidelines do not have the force of law, they may be used in establishing the proper standard of care in a negligence action against home health agencies. For that, Health Information Manager should pay close attention to these accrediting standards and professional guidelines. HIM should be familiar with the legal, regulatory, and accreditation expectations. Another form of specialized patient record is that involves genetic information. Unlike mental health or substance abuse patient records, genetic information may not exist as a separate and distinct patient record. Instead, this information may be contained in any form or part of a health record. Because it can be found in many different places, the potential exists for many individuals to have access to this information. While genetic information may revolutionize healthcare by predicting diseases and revealing cures, it is sensitive in nature and poses special challenges for protecting the confidentiality of information and its potential for wrongful use. Genetic information in the simplest sense means that information about an individual or family obtained from a genetic test or an individual's DNA sample. Science has obtained this information in large measure through the work that has been performed on the Human Genome Project, which was funded by the U.S. Congress, and the Human Genome Project was a joint effort of the U.S. Department of Energy and the National Institutes of Health. Its mission was to map and categorize each human gene. Healthcare providers can use this research materials to assist a patient's well-being. From a federal level perspective, concern over the misuse of genetic information in an insurance coverage decision was so widespread that Congress addressed it in HIPAA. HIPAA specifically prohibits genetic information absent a diagnosis of a condition from being considered a pre-existing condition for health insurance purposes. HIPAA prohibits health insurers from charging an individual a higher premium than others in a group because of the existence of genetic information. In addition to legislation, an executive order at the federal level prohibits the departments and agencies of the executive branch from using genetic information in any hiring or promotion action. The order also prohibits the departments and agencies from requesting or requiring genetic test results from applicants or current employers. Various states have also addressed these concerns through legislation prohibiting genetic discrimination and access to genetic information. The high level of activity by states, combined with increased publicity over the misuse of genetic information by employers and insurers, prompted the Congress to again address genetic information in passing the Genetic Information Non-Discrimination Act of 2008, commonly referred to as GINA. GINA strengthens the safeguards provided by HIPAA and state laws by including additional protections against the misuse of genetic information in insurance and the workplace. Specifically, GINA limits an insurer's ability to use genetic information to raise rates for an entire group and extends the protections to individual health plans. An estimated 1.1 million people in the United States are infected with HIV, the virus that develops into AIDS. At present time, there's no vaccine that exists to prevent the infection with HIV, nor does cure exist for AIDS. As the public health threat posed by AIDS has increased, there are certain misunderstandings that have also emerged. Individuals unknowledgeable about the methods of transmission of the disease have created a climate of fear. From this fear has emerged a stigmatization of and discrimination against those suffering from AIDS and HIV. Legislatures across the U.S. have responded to the stigma and discrimination experience of AIDS and HIV sufferers, as well as the public health threat with a complex mix of legislation. The legislation has addressed testing and reporting requirements and confidentiality concerns. The court system has also responded to AIDS experience, particularly with the context of mandatory testing of healthcare workers and improper disclosure of HIV status. Individuals handling patient-specific health information as it relates to HIV and AIDS must understand the complex legal rules to which this health information is subject of. While there is no one test that has currently been developed that isolates the HIV virus, there is a variety of tests that have been developed to detect the presence of the HIV antibody and antigen in blood and body fluids. The most commonly used tests include the enzyme-linked immunosorbent assay, the ELISA test, and it detects the presence of HIV in serum or plasma. If a positive results arise from the ELISA test, medical protocols generally call for a provider to confirm the result by performing a second test on the same specimen. The tests used to confirm positive results include the Western blot assay, the radioimmunoprecipitation assay, and the indirect immunofluorescence assay. If positive results are confirmed by a second test, the individual is considered seropositive for HIV. The majority of HIV testing that's conducted in the U.S. involves voluntary testing. Voluntary testing for HIV and AIDS is based upon the ethical concept of autonomy. Voluntary testing implies that the individual to be tested has consented to the test. This implication is based upon the ethical concept of autonomy and the individual's self-determination. In addition to written informed consent, most states place a burden on the provider ordering the HIV test to deliver certain pre-test information to the individual to be tested. Often referred to as pre-test counseling or consultation, There are common requirements that include distributing information about the types of tests involved, the testing methodology employed, and the meaning of the test results, the methods of transmitting the disease, and the methods of reducing risk of transmission. Once the test results are available, the provider must then contact the tested individual with the results. The disclosure of test results is also the subject of state regulation. Commonly referred to as post-test counseling or consultation, the disclosure process generally involves 4 parts. Part 1 is at the test results and the possible need for additional testing. Part 2 includes the meaning and importance of the test results. Part 3 include the methods to reduce further transmission, including partner notification programs. And finally, Part 4, which is referral to the available healthcare services and support groups. Where test results are positive for HIV, a provider is required to report the identity of the patient to the appropriate public health authorities unless an exception to the reporting requirement applies. The concept of mandatory testing involves a decision by the legislation or a court to force an individual to receive testing for some health reason without granting the individual the right to refuse. In the context of individuals with positive HIV status or AIDS, mandatory testing generally falls into either of 2 categories, which are court-ordered testing or testings pursuant to statutory authority. State laws empower courts to issue orders to protect the public good. AIDS and HIV status is no exception. A court may order testing of an individual if a court has determined by clear and convincing evidence that the individual is reasonably believed to be infected with HIV and is of serious present health threat to others. Such court orders testing does not allow the individual the right to refuse testing. Statutory authority mandating testing generally targets groups perceived as presenting a public health threat. In some states, this includes prisoners entering or being discharged from correctional facilities. They must undergo testing without the right to refuse. In addition, some states require sexual offenders who are convicted or have pleaded guilty to the crime include sexual intercourse to undergo testing without the right to refuse. These situations generally involve employees' ability to perform a particular job in a safe manner. As it results to some states that prohibit HIV testing of employees as a general matter but allow mandatory testing in certain defined situations. There are many individuals who have elected not to undergo AIDS or HIV testing for fear of learning of a positive result and the possibility of discrimination. In efforts to encourage these types of individuals to submit themselves to HIV testing, some states have passed laws that permit individuals to undergo anonymous testing. Anonymous testing entails a system that assigns a unique identifier, such as a number or a code, to the individual. That identifier then replaces the individual's signature on the consent form and the name on the file that contains the blood sample. It is the identifier, not the individual's name, that is then reported to the public health authorities with the test result. Anonymous testing is unavailable in some circumstances, such as testing to determine the eligibility to donate blood, plasma, semen, or any other human tissue. So at this time, we have concluded Chapter 11, Specialized Patient Records. If you have any questions, please feel free to reach out to me and I'd be happy to help.